즐거운 점심시간 되셨는지요? 이제
If you enjoyed your lunch, we'll now start with the special session. We will look into the growth of the IP litigation process. Will be moderated by partner Yoo Kim of ENG with other litigators taking the panelist position. Please welcome them all with one round of applause.
I'm very honored to host this special session. To my understanding, this session is planned to give opinions about how to improve current court system, and some judges might be uncomfortable but I hope this session will give good advice about the current system, and our judges would be welcoming and open-minded to accept some advices. Yeah. Before starting this session, I would like to introduce myself. I am Uno Kim, and I am the partner of Lienco, and I am currently the president of Korean Intellectual Property Lawyers Association. I want to give a simple explanation about the KIPLA. In abbreviation, KIPLA, we call it KIPLA. KIPLA is an association consists of 1,000 IP lawyers who are dedicated to protect IP rights and promote innovation. And our association, KIPLA, have a strong ties with other counterparty in other jurisdictions. And the one example is EPLAW, European Patent Lawyers Association, and Japanese IP Lawyers Association. And we are planning to host foreign exchange conference in Seoul next year with IPNet, Japanese IP Lawyers Association. And so please I request, give sincere attention to next conference in Seoul. Yeah. I would like to introduce our esteemed guest speakers today. The first speaker is Taecksoo. Please give him a big hand. He is the partner at Baekim & Lee, and he was a founding members of Korean patent law, and he was the first president of KIPLA. And second speaker is Lee Sung-ho. Please give him a big hand. He is of Counsel of Yoon & Yang Korean law firm, and he was a chief presiding judge of patent court, and he served Korean Human Rights Commission as a commissioner. Our third speaker is SungJoon. He is managing partner of Kim Jang and Lee, and he served founding members of Korean Patent Court, and he served as a Korean Communication Commission as a commissioner. Yeah. Our last speaker is Sang-Wook. He is a senior attorney of Kim and Jang, and he is known as a leading IP lawyers in Korea. Yeah. Let me start first from Taecksoo. he will explain about the Korean preliminary injunction and injunction system. And I will say, please understand, from this time on, we will proceed the procedure in Korean, and please use the simultaneous interpretation system to understand.
지금 소개받은 권택수 변호사입니다.
Hello, this is KWON Taecksoo as introduced. The topic that I will cover today is the enhancing the injunction framework, development of preliminary and permanent injunctions. Well, but this is after lunch, so I will try to be as fun as possible. Not sure if I'm equipped to do that, but I will try my best. Then I will proceed with my presentation. So the overview, as you are well aware, the injunction is stipulated in the Patent Act, Article 126.1. And the Korean case law consider it as a right that is similar to the property right claim. And when it comes to the current status, there are damages claims and the injunction claims, and there are cases where the party would claim for both, and there are cases where the party would be claiming only one at a time. So including the ones that the two are pursued at the same time, about 80% of the whole claims are related to the injunction. And I think as for the preliminary injunction, I can just skip that page. And let me tell you about the current status with regard to the preliminary injunction. Well, we are seeing that the number of cases is decreasing, but still it is very well used. And there are cases where the preliminary injunction is pursued even without or before the case on the merits is pursued. And moving on to the main point, which is around the prospective analysis of permanent injunction litigation practice. So in most cases, not sure how this will sound, but we think that the patent infringement is more related, very much equals the injunction. That is something that is considered in practice. And this direction that the legal practice has been taking so far, is that really the right way to go? That is the question that I would like to pose through this presentation. So there are, of course, positive aspects to the injunction, permanent injunction. With the permanent injunction, you can strengthen the position of the patentee by applying the direct sanctions, and there are the aspect of providing remedies for harm beyond monetary compensation, and this is also enhancing the negotiation and dispute resolution amongst parties. But then there are also the downside to it, which is that this is actually creating some tension against the Patent Act, which is trying to promote the innovation and the use of innovation. And this can also be misused as a means to maximize the profit even beyond the recovery of the damages. And also, it can actually cause excessive harm that is unexpected to the infringer. So we need to think deeply about the function and the role of the permanent injunction. The eBay decision is something that you must be very well aware, so I will just skip this page. And as for the next one, I have created a table on what other jurisdictions are doing. You can refer to it in the booklet. I'll skip this page. And I would like to now touch upon the nature of the permanent injunction. So property rights claim is the very general theory that is accepted by most of the academia, and I think there's not much of a disagreement related to it. So this is part of the property right claim and something similar to it. of course, the direct tort approach and also the effect of the Patent Act kind of an approach is something that is considered as part of the academia, but this is not the mainstream. And we also need to look at the purpose of the Patent Act alongside the permanent injunction. So that is why I put it on the right-hand side of the screen. So the patent scheme is having the purpose of promoting the industrial development, and this is the right which is a means to this end, and this is not an end to in and of itself. So when you put it differently, so the permanent injunction does exist for the purpose of reaching the end, and it is not the end in and of itself. So it will need to live up to or meet with the initial purpose of the patent right and the patent scheme. So we will always need to think about whether there is a need to balance the right to the permanent injunction in light of the purpose of the patent scheme. So we will need to consider the following aspects. I have actually prepared 6 different factors that we will need to consider. The first one is the question of whether the patent is practiced. I mean, the patentee, if they are not practicing the patent, and is it really still necessary to protect the patent right then? And the second point that I want to touch upon is the possibility of monetary compensation or monetary damages compensation. I mean, if that can be pursued, do we really have to acknowledge the permanent injunction? And the third factor that we need to consider is the intention of the patentee. If the patentee is using this as a leverage in the negotiation to achieve an excessive return, then we will have to be cautious about it. And the fourth factor that we need to consider is the existence of a competitive relationship. If there is a competitor to the patentee, we will need to consider that aspect when we are thinking about the permanent injunction. That is another factor that I think should be considered. And the fifth factor is the effect of rights. The possibility of the patent being invalid and the remaining life of the patent shouldn't it be considered alongside the other factors. And the sixth factor is the public interest, the market demand and the consumers' interest and the public interest. Maybe we need to consider those aspects when we are considering the permanent injunction. And when we are considering all these 6 factors, would we still come to the conclusion that the patent infringement claim equals the injunction claim? Is this direction something that is really okay? Shouldn't we change our direction a bit considering these 6 different factors? This is the question I would like to pose to you. And based on this, I would like to suggest about 10 hypothetical cases where we will need to balance the permanent injunction. The first case is that only a part of the product has an infringing element. Should we apply permanent injunction even in this case? And the contribution of the infringing product or the part, if that is low, what should we do? And if the infringement of a certain patent of a certain part, if that is leading to the suspension of the production of the whole product, shouldn't we consider that aspect as well? And in practice, in this kind of a case, when only a part of the product is infringing, then if possible, we would be only disposing of that part, that infringing part. And if it is not divisible, then it will be considered as part of the whole. And the second scenario is infringement done in good faith. Based on the patent contract, the licensee receives a certain product And there could be a case where the licensee received the infringing product, and in that case, that licensee would be bearing the losses. And in that case, I mean, should that person be considered infringing too? There are requirements that are stipulated, but still, even if that is there, even if the infringer is doing it in good faith, shouldn't we consider that? I mean, our consistent view is that for this type of an aspect, I mean, even the negligent party will need to still bear the responsibility, but there is still a stipulation in other cases that the percentage or the proportional application is possible, but then for the permanent injunction is not possible, so maybe we will need to consider that aspect. And the third hypothetical case is where the patent has a possibility of being invalidated. Should we still acknowledge the permanent injunction in this case? I mean, the abuse of rights could be a way of defense, of course, but when it comes to the invalidity grounds, I mean, of course, this is related to the preliminary injunction as well, but this is actually delaying the hearing process, overall procedures, so we will need to think about this aspect more deeply. And the fourth hypothetical case is related to the NPE, a so-called patent troll. If they are exercising the permanent injunction claim right to pursue profit, is it still something that we will need to consider? There are cases where the foreign companies pursue the permanent injunction cases in Korea and against Korean company. Shouldn't we consider that aspect? I mean, there were 321 cases, such cases so far, and these kind of suits that are pursued by the MPA, should we continue to allow it? And I also prepared other 5 different hypothetical cases. The 5th one is related to the technical standards. I mean, for example, if the technology is used for the standardization and the permanent injunction is pursued against it, should it be also granted? And when it comes to for example, the 6th factor, if the patentee does not have any intention of practicing or implementing the patent, should it still be acknowledging the permanent injunction? And the 7th aspect, when the permanent injunction is becoming the hurdle to the technological development, should you acknowledge it? And this 8th one, which is related to the public interest, the patents that have a high relationship with the public interest, should we consider that? And the 9th factor is around the exercise of permanent injunction colliding or being in conflict with the other laws' legal interest. For example, when it comes to the Fair Trade Act, there could be the legal interest conflict, and should we still acknowledge the permanent injunction right? So I have given you about 9 different examples here, but maybe the 5th factor that is related to the technical standard, I mean, we saw it in the Apple v. Samsung case related to this patent. There was a decision on that aspect from the Korean court. And the DSBU preliminary injunction case, I mean, that was dismissed in Japan as well, and we do have to consider those aspects. And the last one, the 9th factor, which is related to the Fair Trade Act. Recently, the KFTC, I think, has made a notification that it will be making modifications to the enforcement. If there is a patent infringement lawsuit with the intention of misusing it, then this would be considered unlawful. That is notified to be included in the new revised guideline or the enforcement rule that the KFTC has. So we will need to wait and see how it unfolds. And the other part related to the equity between the patentee and the infringer, this I think you can refer to it from the back booklet. And then let me move on to the third point, which is to diversification, which is related to the diversification of permanent injunction types. So when it is infringing, then we are giving injunction. I mean, that is what is done in practice. And in light of that practice, I am not sure whether it will be possible to allow multiple variations of the permanent injunctions, but I really hope that you will give a thought about this. So when it comes to the prohibition of practicing patents in certain manners during production, use, transfer, lease, or import, maybe we can consider this. Maybe we can acknowledge a wider discretion by the judges in the cases that is laid out here. And next is the preliminary injunction, but this is something that you are very well aware of. But when it comes to the preliminary injunction, this is actually very much becoming like a litigation on the merits. So when it comes to its benefit of being a speedy process, it is being undermined these days. But if the result of and there are many cases where the injunction decisions are affecting the litigation decisions, so that will need to be thought out very deeply. So that's one comment that I would like to leave about this one. And moving on, when it comes to the preserved rights, well, the balancing is needed, as I said earlier. And there was a decision made by the Japanese IP High Court, and this is the Samsung v. Apple case. And in that case, there was a case where the case was dismissed without prejudice because it constituted abuse of rights. And these, I think you are already aware of this, so I will just skip this. And the security deposit, I think I can skip this as well. And the most important or debated aspect is around the invalidity decision. When there is an invalidity decision pending, then the injunction decision comes late. And there are cases where the injunction decision waits until the invalidity results comes out, so that causes delay. So in that aspect, maybe having in patent offices measures in place so that we can lower the percentage of the patent invalidity is something that we will need to consider too. And the stay of enforcement of a preliminary injunction, this is not something that is really acknowledged in practice, but we will need to once again think about this aspect. I will skip this part, revocation, and the integration or decentralization of the jurisdiction is really important. And now the appeal is actually centralized. But then when it comes to the preliminary injunction, the injunction appeal still goes to the high court, so it is scattered across the country. So this is something that the legislative effort will need to focus on, so that such injunction appeals are also centralized. And due to time constraint, I think I had to rush a little bit. But what I want to say is that regardless of it being the permanent injunction or the preliminary injunction, patent infringement equals the acknowledgement of the preliminary injunction is the direction that we are taking in Korean courts now, and I really hope you to think deeply about this and reflect on this and whether this is really the right way to go. Thank you.
he will give some advice on the damage system in Korea.
안녕하세요.
Good afternoon. Well, we have Chief honorable judges from IP area, so to be able to deliver this presentation in front of you, it's really an honor. I've been lawyer not that long, so still, if I dream, I don't dream as a lawyer, but actually as a judge, where I have to settle things, although I wasn't grasp the core of the issues at hand in various cases, in a case, and also in preparing this presentation in 1998, 26 years ago, before actually opening the IP court of High Court of Korea, I actually created committees to create the laws, regulations governing over the IP proceedings and other things that I did for the establishment of IP court become reminiscent of them. So when it comes to judicial practice and also academic research in the IP was actually facilitated through the establishment of IP High Court, and as a specialized court, IP court was able to protect IP rights. There's also promoting more investment from overseas. So I'm really glad to see that we have done the right thing, and I express my respect to those that followed in that footstep and are still working hard even this day at the IP court system. So today I'm going to talk about directive improvement of damage litigation, and academically it's not that difficult area, and probably the content-wise you already know. So it's kind of a reminder. So not as an attorney, maybe I'm telling you this as kind of a judge that a senior judge that went before you. Now I'm going to talk about enhanced case management, concentrated hearing, effective evidence collection, and how we can calculate damages. So I'm going to focus mostly on these three areas in my presentation. So in the introduction part, what I wanted to emphasize is that IP High Court is a specialized court. So if you think about people coming from other cities to Daejeon, and, the hearings at the IP court needs to be done in a concentrated manner. But to allow them, not only does the IP High Court do its job faithfully, even from the first instant court, it ensure more thorough hearings. And when you do practice as laws, document collection order things sometimes are not that effective. So there are still issues in terms of evidence collection, in terms of calculation damages as a result. It's not. It's mostly discretionary basis rather than based on exact numbers or grounds. Hence, by having more effective evidence and facts, I think that would also be inducive in terms of having more effective damage calculation. That would be kind of the overall view of my presentation. Now, when it comes to issues related to patent litigation, in terms of case management, there is a lack of proactiveness. And in the appellate hearings, like in the first instant hearings, there is a lot of repetitions, looking over the same things which we already did at the first instant court. So looking back at my experience as lawyer, judge as two, in the U.S., they amended, civil procedure rules in 93, and also civil proceedings were amended in 96 in Japan. So in terms of the role of judge, they went further from just becoming mediator that was neutral. They actually assigned the role of having become more a proactive case manager. So I believe, Korea has done also some things, but mostly, and I also should have done better in that area, but was rather passive role as a judge, more as a, judging things rather than being proactive in intervention, and that's maybe hindered a more proactive review cases from the first instance court. And because of that, even the appellate court of the IP High Court, you still have to go through the evidence there, thereby delaying the process. Hence, ultimately, then, how can you calculate the damages? First, let's look at how the U.S. and Japan has done, because they amended the rules before us, and maybe we could at least learn from what they did right. And in that context, let me introduce. Here there's an introduction of the U.S. and Japanese legal system. In the U.S., when it comes to case management portion, the pre-trial conference and discovery, that will be the portion related to that. Now, pre-trial conference is very similar to our preparation process, so I'll just skip that part. So in the pre-trial conference, it's a bit same or similar to ours. And then in terms of discovery system, that is the biggest difference from the Korean regime. And of the discovery system, what I would like to particularly bring your attention to is that between the parties, the first initial disclosure process. So this initial disclosure, in the federal rules, it did not exist, but in amendment of the 1960s was actually included. So when it comes to infringement-related damage litigation, at the beginning of the filing of the lawsuit, plaintiff first thing to disclose will be the base grounds for damage calculation. So based on the evidence it proposes the damage and related evidence document used for such a calculation needs to be submitted in automatically. So that is the interesting point. And if you look at also various guidelines and manuals in terms of patent proceedings, this has been emphasized. So in the beginning, the court, what is the size of the case? How should we approach this? And in terms of the amount, they need to roughly have a estimation of the possible damage to assess whether there's any possible settlement and what should be the schedule of the proceedings. And because of that, I think the key is that plaintiff give you disclose everything that you have. But do we have the same kind of approach in Korea? Well, we do have similar thing in the Article 246 of the Civil Proceedings Act, and it says that we need to specify your evidence, and you also need to submit all the related documents. So this means that the plaintiff files a case, then it also means you have to disclose everything you have. It's not like we cannot argue for something not before the defendant gives us the information. So we don't wait for that. So it also, in the same Act Article 146 also says all the evidence and information needs to be submitted, and based on that, or if the damage calculation related information is all submitted from the get-go, you could sort of manage the case, foresee what should be the schedule, and based on the sides involved, you could be more inducive toward going a settlement and in other alternative resolution approaches. So not for appellate, but at least for the first instance, if they do this part well, I think it would increase efficiency. In terms of violations of the documents of production, there are various penalties involved. For example, like you can dismiss the case, or you could like let the other violating party bear the litigation cost. So if they violate the order for document production, we could also have similar penalty process as they do in U.S. Next is the Japanese system. And due to time frame, I think I need to be fast. But here it says in 96, for concentrated hearing process, they amended the rules, and they also amended the rule after that once again 2003 for expedition purposes, and based on that, different systems have been introduced. Now in Korea, we also introduced some of the systems, but in practical sense, it's not really being widely used. Hence, it didn't really result in material changes in our hearing and proceedings. That's my opinion. And you have pre-filing inquiry system and pre-filing evidence collection disposition system in Japan that's been newly added, and also issue identification procedure, very similar to our process. Now, planned hearings. Now, it's a complicated case when you have to determine damages on infringement. And for such cases, planned hearings is mandatory and something that we could take note of to maybe have in Korea. And also appraisal calculation of damages. In case of Korea, plaintiff or defendant actually ask 6 expert opinion and just submit that as a but whether there has can be if the power as evidence is doubtful, so maybe we could also learn from this calculation damages system. And in other countries, when it comes to IP lawsuits, mediation, arbitration are actively being used. So that is the part I believe is most lacking in our judicial practice of Korea. So in case of Korea, for first 61% of first instance civil cases resolved through settlement. In the table, even only in IP cases, 53.33% go settle. And I went to the website of Japanese system and looked at the centralized mediation division, and looks over all the mediation and it settled through all cases 60%, and takes very short time to do that. And in U.S., more than 90% of IP cases are settled. But in case of Korea, it's less than 15% also. So this is part where we can do better, I believe. So all judges have to write the judgment, and it takes a lot of time to write it that up. So actually, you cannot therefore invest a lot of time in terms of hearing and looking at the evidence, which is regrettable. Now, it does some conclusions, but I do believe I covered most of them, and due to time constraint, I need to skip this part. Effective events collection system. Well, for Korea, e- document collection production orders are in place, but there are many cases where the litigant do not comply, and that also do not result in effective sanctions, which is also a problem. And also in-camera procedure, how can we utilize that and improve upon that? We do have in-camera procedure. However, in terms of mandatory document production, we could do more, and also in in-camera procedure, allowing the legal representatives to take part or expert to take part is something we could do because it exists in other countries but not in Korea. So we need to just go through the slides. Now, in terms of document production, if there's non-compliance, I talk about having effective sanctions, and in calculating damage, that should also be reflected. And lastly, I'm going to talk about the appropriate calculation of damages. Now, even this collection system is not really effective, so damage calculation in terms of it's rare. It's based on the substantiated loss calculation, but it's actually done at discretionary of the court, so it actually estimated in most cases. So in Korea, punitive damage is not really done. So that means you're forced to pay damage. And even if you fail in the first instance, you could actually ask for suspension and continue with your litigations. So it's better to continue with the infringing. You can actually continue with the infringement act if you play the system very well. So I think punitive damage system, I think needs to be boldly adopted to discourage such abusive system. But anyway, again, from the first instance, case management needs to be done more better. I mean, I was asked to talk about damage calculation. So, plaintiff proposes damages and related evidence and use that for early settlement or for planned hearing would be better. And for, document production order, if they don't comply, more sanction needs to be in place. And also damage calculation needs to be in place. That will be my 3 conclusions. Thank you very much.
Thank you for your presentation. The presentation include even other jurisdiction statistics. It's very inclusive. Thank you. The next speaker is 최성준. 최성준 변호사님 would provide a recommendation for the improvement of invalidity process and scope confirmation process in Korea.
Yes. Good afternoon, everyone. As I was preparing for this conference, when the IP High Court was first established in 1998, the overall circumstances were not fully ready, and the work was still being done with not the full environment being ready. I used to work here back in the days, and afterwards I have seen that the IP High Court in Korea have made a lot of progress. And as Attorney Lee just mentioned, I mean, this has become a very successful case, which can be represented very proudly any part around the world. So talking about the improvement points about the existing revocation action is something that I was very cautious to bring up. But as a person who came in before you, I really would like to share my thoughts so that we can make an improvement together. And in the next session, we will be talking about the artificial intelligence. And when it comes to the inventiveness, inventive step of the patent, I mean, we cannot not talk about the artificial intelligence, so I will touch upon that aspect as well. And this is the agenda for the day. And among these items, number 4, which is related to the Trademark Act, I think I should just skip it. I mean, I was able to see that most of the discussions are focused on patents only, so I will be skipping number 4, which is trademark related item, and we'll cover 1, 2, 3, and 5. And when we talk about the revocation action, I mean, we cannot not talk about the inventiveness. And inventiveness is an item that cannot be very easily or clearly defined, but is a topic that should be covered. And when it comes to increasing the predictability of the inventiveness, this is very important. And when it comes to the general principle, there are 3 important ones. The one is the Fosita's technical level, and the other one is whether this is something that can be easily thought of based on the state of the art at the filing date. And the third one is that how easily it can be made from the prior art. And when it comes to the Fosita, I mean, this is playing a really important role in preventing the hindsight reconstruction. I mean, if you are considering the Fosita skill level too high, then it would be difficult to recognize. It would be difficult to recognize the inventiveness, and it would be easier to recognize the compliance with the specification requirement. But then when it is too low, it would be the opposite way. So it is very important to ask about what is the right level, appropriate level of the skill of the Fosita. And as I put it in here, the utility model review system in Korea does define the skill level of the Fosita, and what you should focus on in here is that in the later part of this description, it does talk about the person that is an imaginary one who can have the creative ability of doing the following things. And according to the Supreme Court decision, there is no clear description that is given by the Supreme Court. But when it comes to the patent decisions, patent court, I mean, they did add a few more comments to it. So it did include the point in time, which is at the point of the filing, and it also added that regardless of it being domestic or international. And when it goes down to the nitty-gritties, what is the skill level of the Fosita? I mean, explaining the skill level of the Fosita and defining the skill level of the Fosita, how can we do this? It is still unclear, and this is the question that we have to deal with. So, according to the Supreme Court decision, the skill level of the Fosita should be determined based on the records and the materials available. But if we are to do that, how can we actually acknowledge the skill level of the Fosita using the existing recording and materials? I'm sorry, I'm on a wrong page, it seems. So this is a procedural law related item, and this is a requirement standard. So of course the adversarial system will apply, and the parties bear the responsibility, burden of proof, and the court, of course, will need to be making the establishment of the facts using the evidence and the arguments that were presented to the court. And the skill level of the Fusita, I mean, there are cases in the Supreme Court where it was defined as a person who has the bachelor's degree in a certain art and has the 5 years of working experience in, for example, plating. But it is still not clearly defined, and there is still room for further discussions. And when determining the skill level of the Fusita, so when determining the skill level of Fusita, another factor should be considered, which is the technical field in question. So how will we define the technical field in question? Technical art in question is also another really important question. If we acknowledge it to be a very wide scope, then the level of the skill level required for the Fusita will become too high. And there are some concerns about it. I'll touch upon this later. And recently, researchers are using AI, and that is affecting the skill level of the Fusita. So that actually gives a little bit of an ambiguity in how we will define the skill level in the technical area. The skill level of the Fusita and the artificial intelligence does have some relationship, so let me touch upon that topic. So the skill level of a Fusita is basically based on the researcher's ability at this time. And they are now receiving assistance from the artificial intelligence. So when we are determining the skill level of the Fusita, we should look at two different factors. The one is the knowledge, and the second is the creativity. And when it comes to the creativity, many researchers in modern times are receiving help from the artificial intelligence. Artificial intelligence does create art, but it's not even about that. When artificial intelligence is used to assist the creation of invention of a person, that would be considered the means, but then there are other cases where the artificial intelligence plays a even bigger role than just being the means. And there are many cases as such these days. So if the artificial intelligence plays a role in the creation in and of itself, then it will result in a higher level, higher maybe quality of creation or invention. Of course, when we are determining the skill level of a Fusita, we will need to think differently about the level of artificial intelligence usage. I mean, there will be areas where the artificial intelligence is widely used, and some other areas artificial intelligence is less used. So if we define it unilaterally across the board, it may also create complications. So the creative ability of the invention would be enhanced using the AI, and in that case, the existing inventive step standards is only based on the human researchers, and in that case, the patent would be granted more easily than it should. And this problem is dealt with in light of the current situation where the level of invention would be enhanced because of the use of AI, and we will need to adjust the bar accordingly. But some people argue that we will need to change the concept of the Fusita completely. Maybe we shouldn't just define it as an ordinary person. we will need to define the Fusita as Fusita using an AI or even an ordinary machine or AI, but I think it may be too immature to uh, conceive that idea. And when it comes to the ease of invention, so when we are making a judgment, we are also looking at the ease of invention and the specific judgment around that will need to be clearly written in the judgment, but that is not exactly done so well in practice. And the ease of invention is also closely related to the use of AI. And when it comes to the ease of invention, of course, the skill level of a Fusita is a really important issue, but then the AI, if it is used to help with the creativity, there could be a wider possibility of people making inventions more easily. So the standards or the requirement of inventive step can only get higher. And moving on to the hindsight aspect, I mean, we all understand that the hindsight reconstruction should be prevented. It is almost taken for granted, but of course, it is very difficult for a natural human being to think like they don't know something that they already know. So this is an area that is considered very tricky. And the Supreme Court also declares the principle that the hindsight reconstruction should be prevented, but then on how it can be prevented, it does not specify as to how it can be done. So I personally thought about ways to prevent hindsight reconstruction. And I thought about some examples how they can be prevented. Not sure whether this is realistically possible, but when the person who is deciding on the inventiveness, that person I suggest should read the prior art documents first before reading the specification of the patented invention. In that case, the contamination in the thoughts could be minimized, and the prior art will need to be defined very reasonably in the analogous art. And when it comes to looking at the combination, how easy the combination is, we will need to look at how a Fusita, if there is a possibility that a Fusita would be able to make that combination, and whether the source of the technology is coming from the same or the adjacent art, or whether there is a reasonable ground for the combination. And moving on to the confirmation trial related to scope of rights. And for the international guests here, maybe you may not have good understanding of this system, but in Korea, we have had this system for a long time. And the appeals related to the patent infringement is being centralized, and there is a question as to how valid and how effective this trial system is. The Supreme Court does believe that it does, still serve the certain function, so it does acknowledge the validity of this, effectiveness of this, but then when it comes to the confirmation trial related to the scope of rights, it does have a lot of problems, as I would explain further later in the presentation. And recently, with regard to this confirmation trial of the scope of rights, we have seen multiple Supreme Court decisions. One is related to the 2014 decision. That was the infringement, but when it comes to that can be decided by the court, but then when it comes to the confirmation trial, it cannot be checked there. So it did made an effort to distinguish between the two. But in 2017 decision, it also allowed the free to use technology argument too, so this has been kind of undermined as well. And the Supreme Court En banc decision 2011, it also stipulated that when there is a conflict between the implementation of a later filed patent or utility model right and the earlier filed patent or utility model right, then the infringement is established. So there are some conflicting aspects to the decisions made by the Supreme Court with regard to the confirmation trials. So now I would like to suggest that it is time for us to maybe reduce the role of the confirmation trial and even think about whether this is really necessary, and maybe it is time for us to eliminate it. And third point that I would like to touch upon is related to the correction trials. I think the correction trials are excessively abused these days, and there are some cases where it reaches the Supreme Court and gets remanded. So recently we received a en banc decision. So when the revocation trial, a result comes out after the fact-finding procedures, then even if the correction trial is confirmed, that would not be considered as the changes to the administrative measures which served as the foundation of the decision. But still, there are many issues at hand, and we need to understand the intention of the Supreme Court clearly and find maybe the time frame window for the correction trials. And lastly, I would like to have a few personal comments. According to the civil procedure rule, the document length should be up to 30 pages. And of course, if there is an agreement with the court, it can be adjusted, but there is a rule that it should be limited to up to 30 pages. But then in practice, this is really not complied with. And as I am practicing as an attorney, if I want to put in everything that I want to put in, then it very often, goes beyond 30 pages. And as a counsel, of course, I will have to be very cautious about it. But there is one comment that I would like to give to the IP High Court. When the, attorneys give you this lengthy, submissions, think about why that is the case. I really hope that the tribunal, the panel, have good understanding of the earlier submissions. If that is the case, the attorneys will not have to rewrite. Once again, write the same thing that was already described in the earlier submissions. So please, there is one, I would say, comment that I would like to make to the judges, that you should be very well aware of what was already submitted to you beforehand. Thank you.
Thank you for a nice presentation. Next speaker is Sang-Wook 변호사님. I'll ask him to give overall evaluation of current IP system from the perspective of clients, especially foreign clients. Please give a presentation.
Thank you. My name is S.W. Han, the attorney for the KWON law firm in Korea. And today, for the sake of efficiency and given the limited time, allow me to present my materials in Korean. So for the foreign judges and attendees, please try to follow the screen. Sorry about that. 안녕하십니까, 한상욱 변호사입니다.
Yes, good afternoon. I'm Han Sang-Wook. So within the limited time frame, I want to share with you my thoughts. When I was first invited to this conference through our moderator, Kim, I believe this might be the last presentation for me, because we have excellent IP lawyers that are junior to me, and I believe I've attended all 10 conferences of this IP court conference for the last 10 years. So this 10th conference is very meaningful to me and to my junior lawyers. Always say IP is not one of them. It's not one of the laws, that it's a very special area, special roles. And what's been proven through this event is that in a court conference, we have, chief justices from high courts and Supreme Courts in attendance. I do not believe no other areas would bring out such a kind of the higher up. So I was very proud of this. So I do have many slides, and you can all forget about it, but please remember three things: international, tribunal or the courts, and also second, Korean hearing, and thirdly, it's the RCAP IP court. So these are the 3 points I would like to emphasize.
Today, my topic would be three ones. The first, Korean judicial panels. And then secondly, to prevent the hindsight, I'll talk about the Korean hearing. And thirdly, RCEP IP court, which is quite similar to the Asia IP court concept.
Now, UPC and ITC of the United States, how the inner workings of them, I do believe yesterday and also this morning, our honorable judges actually presented on them, so I'll just skip this part. But if you have time, you could maybe go over my slides. Then, why, like UPC or ITC, or the Singapore court or Japanese court, why do we need to look at their practices? I really do not believe we are in competition with them, but at their courts, why are they have more cases than us? And is there anything that we could learn from or reference? Plus, of the ICT cases, there are also, of course, they also fought in the Korean court, but there were cases where if two Korean companies fought also in ITC. So for Korean court, maybe they went there because Korean court ruling was not sufficient enough. So in that case, we also need to take note of them. So as a practitioner to my international client, I always talk about the benefits or the good things of the Korean court system. So there are many, but it's about international judicial panel, which I'd like to explain more to you a bit later on. And then not only preliminary injunction dedicated division, which was established in 2016, do exist. And I believe to our international clients, it's impressive. So I actually two-tone about that. And also at the High Court, having the presentation practice at the first hearing, I do believe it's very efficient and effective. Of course, after even presentations, few more hearings are necessary, but it's very impressive. And also, there are provisions the Unfair Competition Prevention and Trade Secret Protection Act. I think it's very much. I heard the Japanese side was very impressed about that. Document production orders and damage-related rules in that is dedicated on this area because injunctions sometimes are recognized, I believe, in the practice in Japan because it's based on the general damage calculation or anyways, punitive damages is also something we should also take of note. And also, I didn't put this in here, but the fact that we are looking at the timer, yes, timer also makes me heart throb every time, but I do believe it's actually a good practice. Then with KTC, now we do have Chief Judge of ITC here too, but we also have KTC in Korea, and I believe Korea is the only country, I mean, there are few that only exist in Korea in terms of IP regime. First is that we do have KTC, and second, at the customs, there is a system where they can prohibit related IP, and of course, court to then could that too. U.S., I believe, cannot do this in customs, and in other countries they don't have KTCs or TCs besides Korea and the U.S. So I believe Korea is the only country that have these three systems. And KTC is improving very much day by day. So on the far left, for example, from China or from Japan, goods was made and bring it to Korea. So even if they were not produced in Korea or licensed in Korea, we still have the right to investigate. So it's a kind of exemption to territoriality. And fourth box, within 6 months of the investigation, you have to make a decision, and if there's extension within 10 months, and it's very much strictly abide by. So by KTC, so it's something that we are doing well, and also special judicial police also I do believe garners a lot of interest. And so these are something that we should be proud of. And so if we are doing well in these areas, then we should also think about, is there any room for improvement? Because we can always make things better. But anyways, then what would be suggestion for improvement of Korean courts practice? So in that context, let me talk about the Internet Judicial Panel. So in 2018, our also the judge of the Supreme Court in the keynote presentation also said we also amended a court related act. Before that, court language was only in Korean, but with the International Judicial Panel to allow the pleadings in English, they actually amended the law. And I still remember the IP court chief judge and others even went to the National Assembly to explain their case. And after that amendment was passed, few gathered together to actually party about, celebrate it. But so I still have vivid memory of that. But it's being underutilized, and some people, even in the practice of IP, do not know its existence. So that's very regrettable. So there is a Supreme Court rules, regulations of 2018 that's regarding the International Judicial Panel. We have a lot of Supreme Court judges joining us also in this court. So again, if you have the rules on this under Supreme Court, there is a lot of more things we can done. So maybe we could also think of that way. So not only maybe English, also allow other languages. And now both parties needs to agree, but maybe one party applies and can be done through court decision, could be one way. And as an International Judicial panel, Judge talked about having in Sondo, and also the qualification of the attorney should also become more laxed. And Singapore, SICC, they even have foreign judges. And to do that, Singapore, I believe, as our judge knows, said even change their constitution. So I think we need to be more open in our thinking and flexible. The focus is about resolving the dispute, and in order to do that, what can you do more? To the applicant, if you can give more benefits, like as I said, KTC, you resolve cases within 6 months. So maybe benefit in discovery or faster decisions or judgment, that type of benefit, I propose could be taken into consideration. Now, case main conference was covered a lot in the morning. So I think in terms of adoption in Korea, I don't believe it would be very difficult because there's a lot of also a court that makes us very much predictable in terms of case management. So I think there is a inducive ground to introduce them. So maybe setting all the schedules at the first hearing would be beneficial, as I've seen also done in Japan and other countries. And also Korean hearing. Now, if I go in this area, maybe some will say, oh, you are going into that again, because I always talk about this. But Professor George Mendel, I also saw him in person, actually had the three groups, foresight, hindsight, and debiasing group. And foresight group is only give technical scenario and don't tell how it was invented. So like baseball or fishing rod will be the things they need to create. Hindsight is they told the group how it was invented, and devising group is they told how it was invented and then said informed the problems of hindsight reconstruction. And the results are quite interesting. If you look at only on the obviousness area, this interesting is that the one that know the answer, hindsight, and the debiasing group, there's not much of difference between the two groups. But in foresight group, it was only 10%, so it was rather low. So I agree with Attorney what Che said. So in submitting the briefings to the court and also in doing hearings, you cannot talk of patent invention, and from the Posita perspective at the time of application, like we go back to like 2001 and based on the literature at the time, explain it. Like why is it easy to have the patent invention? That type of hearing, I believe is necessary, and I've said that in many different occasions, and there have been a court that adopted this opinion too. But anyway, it's still very rare. And I think Markman hearing, everybody knows about this around the world. So maybe we can call this as a Korean hearing. That was my proposal. And at IP High Court, and also if you do have Asia IP Court, I do really hope that this can be adopted. And then looking at the IT technology level of Korea, I believe it's can be recreated at court. And if we have the international jurisdiction panel, even with the video conference, you can recreate that. And I believe it's easy to have automatic translation service also. If I say something, have the translation on video. And so we can create a special court setting like in Songdo to promote the advancement of the IT technology of Korea to the world too. So again, IP's role is changing, and also ITC of US and KTC of Korea, like them, the administrative aspects can be introduced also in the IP court regime, and also various appealing process of the trade commissions could also be introduced to the court system. So what is RCEP? You might be wondering. It stands for Regional Comprehensive Economic Partnership. So in 2019, with 10 ASEAN countries, along with Korea, China, Japan, Australia, New Zealand, within these 15 members, they created IP agreement, and it assigns a higher level of obligations than TRIPS. So also when I posed questions yesterday from the floor, it says EPC took more than 50 years in the making. So I do see that. But we don't even have any discussions about this establishment of the Asia's court. But that's not true. We do have ongoing discussion about this, and if not Korea, but other countries are also open to host the location of RCEP court. So we have made some progress in this area already, and I really hope that our practices of Korea, because there is a lot of good things that Korea already does. So if that can be introduced and be helpful in the RCEP IP core, it will be good. And maybe through that, Korea can take a leadership position in these efforts too. Thank you very much.
Thank you. Thank you especially for the introduction of Korean good practice and system. We can take pride. I would like to give several questions to the speakers on the presentation topic today, but we are pressed for time. I ask small questions only. 변호사님께 먼저
I have a question to Mr. Kwon. First, according to what you presented, when it comes to the right to claim injunction, you touched upon the need to consider the purpose of the Patent Act. The right to claim for permanent injunction may have to be limited in light of the patent scheme, the purpose of the patent scheme. But under our law, it does say that the patentee can file a permanent injunction claim against the infringer. And in a certain condition, you would like to make it limited. But then, do you think that wording is enough to apply the permanent injunction in the way that you wanted, which is an unlimited scope? Or do you think we will need to create another provision that is allowing the judges to do so? As you are well aware, Patent Act and the patent right and the property right are two different rights. And as for the patent right, it does have a stronger public interest nature compared to the property right or the ownership right. So we can think about many different aspects based on your question. One aspect is related to the General Civil Act principle, and the other one is around the abuse of rights or the good faith principle being considered as part of the need for the permanent injunction. And we can also look at it solely from the Patent Act perspective and making a balance using only the Patent Act to make that right balance. And the fourth, probably the way to do it is to look at the case by case basis. And when the clear invalidity grounds are there for the patents, then they would, the Supreme Court would acknowledge the abuse of rights to make a decision. But that is something that I am not happy with, to be honest. So using the civil law principles to make a judgment in that aspect. I mean, this permanent injunction is actually stipulated in the Patent Act, not in the civil law. So the damages claim right is stipulated in the Civil Act, but the permanent injunction in light of the patent is actually not just a civil act. It's different from the property claim right in the civil act, civil law. So ultimately, we will need to revise the Patent Act to be able to allow for more discretion of the judges. So I would say that I think it is necessary for us to maybe add a new provision with regard to that. But when it comes to reality, it will take time to make such revision.
그 과정에서도 사실 저희들이 뭐 전직 금지 같은 경우는 법에
And
따르고 전직
for
2년
the
제한이
non-compete clause, I mean, it doesn't have the specific duration, but based on the precedents, I mean, it does specify it as a 1 year in many cases. So, in such just like that, maybe we can do the same here. Even until the revision is in place, we may be able to allow for a certain time frame or certain scope based on the discretion.
금지 청구권을 일정 경우
Thank you. So making some limits to the permanent injunction, on this view, what are your views? I would like to hear from the three other attorneys in order, please. Starting with Mr. Lee. As for the preliminary injunction, it is related to the preservation need, and it's also related to the public interest, and the dismissal can be done based on that consideration. But when it comes to the right to the permanent injunction, if the violation or the infringement is objectively acknowledged, then it would be considered as a right that can be claimed. So based on the current status, it would be difficult to apply the discretion. And that can actually weaken the protection of the rights, and it could also undermine the legal certainty as well. I mean, the pharmaceutical medicine, drug making, or the, invalidity of a patent could be the exceptions. But if you are applying the balancing act across the board, it may be a problematic too. Yes, thank you. And the next one, please. I agree with what Mr. Lee Sang-Woo just said, but I can see Mr. Kwon Taecksoo's point. I mean, this is a very meaningful point. He touched upon a really meaningful point. This is worth reviewing, but there is a prerequisite, though. The prerequisite is that, as Mr. Lee presented, the damages system will need to be first clearly established. So, if you pursue a damages claim, then you will receive a bigger compensation or the equivalent amount of compensation, and your rights will be protected. I mean, if that can be guaranteed, then we will be able to put in some balancing act related to the permanent injunction claims. But at the moment, it is not the case, so maybe it will be too harsh on the rights holder, which should be the patentee here. I see. So we will need to consider it even more holistically, including the damages system. And moving on to Mr. Han. Well, without the revision of the Patent Act, applying this discretion would be quite difficult, I think. And we heard from the U.S. about the eBay case. I mean, there was a revision discussion related to it. And the ITC, as you know, when the infringement is acknowledged, then the exclusion order is acknowledged. So in practice, as of now, we don't want to see that the protection of the patent holder being even more weakened. Thank you so much for your input. So the injunction and the damages are two big pillars, so we will need to have a good balance between the two pillars to be able to have a stable legal system. Then let me move on to the damages, because we are on that topic. When it comes to the damages system, many people believe that the Korean damages system is not sufficient. I think many people think that. So if that is the case, if the damages system in Korea is not sufficient, what do you think is the root cause behind it? What would be the biggest reason behind the insufficient damages system in Korea? And let me ask this question to Mr. Lee first.
뭐 발표문에서도 얘기.
Well, as I said in my presentation also, now for more effective damage compensation, the interest of the infringer and patentee needs to be estimated based on factual evidence. But we do not have discovery systems, and even the evidence that production orders are complied with. So we cannot give more accurate calculation, so it's based on the court discretion, thereby resulting in ambiguity in terms of the number calculation. So in terms document or in the evidence collection and production, court needs to become more tighter in terms of supervision and needs to becoming more effective. Okay, so in terms of inventive step issue. Now, what is inventive step and what's non-inventive step of the invention? So I think the key is which criteria you use. What is the standard? So you said there should be clear standards involved. And one of the things that we could consider
Would be that, which is something that is not really considered so much by the Korean court, which is called the second consideration. At the moment, the Korean court actually considers it only as a supplementary opinion, but then maybe there is a need to consider it more closely. Maybe having it as a main consideration. What do you think would be a better option, Mr. Che? Well, this is related also to the hindsight reconstruction. And the secondary consideration is, of course, secondary, so it cannot be primary. But in the Korean law practice, the secondary consideration part is considered very lowly. It is something that is not considered very importantly, so we will need to consider that aspect. And in practice, I mean, I did this when I was practicing in the past, but when we are thinking about the infringement and the inventiveness, I first consider the construction, and if there's no much of a difference there, then the effect is not really very much explained. But so if the difference in the construction, I mean, can that be overcome by the inventiveness? I mean, that is not really connected closely with the effect in the explanation. So maybe this will not just have to be the secondary consideration. If that is related closely to the effect, then it will need to be considered as a more important aspect. Thank you. The representative consideration would be the sales, and this is definitely an objective, information, so that will need to be considered by the court. That was your opinion. And moving on to Mr. Kwon, I mean, what do you think is your view? What is your view on the secondary consideration? Well, inventive step is something that is most tricky when we are considering the validity of a patent, and I am not always very confident about this. I mean, I felt that as a judge, and I am also feeling that as an attorney at the moment. I mean, whether this is inventive or not, there can be different views depending on where you look at it from. So it's a very tricky part. And the secondary consideration, I believe, is considered as like 5 to 6 different indicators in the U.S. I mean, this is a consideration that is widely used in the U.S. I mean, licensing, experts, pessimistic view, and the imitation of a competitor. Those could be the major factors that are considered in the U.S. But in my view, the most important thing that should be considered when we are talking about the inventive step is the task or the challenge that was not tackled for a long time. And this is actually a very important aspect in the technical development, and whether this is invention that is hard to achieve by the Fosita is also seen through this indicator, and this is something that can be easily proven too. The commercial success is something that we easily take or accept, but the commercial success can actually easily also segue into an hindsight consideration too. So we should be very careful. Thank you. Thank you so much for your opinion. Moving on to the confirmation trial and the infringement proceedings, them being overlapping. Mr. Che gave us that sort of opinion when he delivered his presentation. And about this, the confirmation trial, based on what we learned in the past, I mean, this is a type of proceeding that is existing only in Korea and Austria. So the confirmation trial for the scope of rights, I mean, should it be maintained? I think there are a lot of discussions about this and many question marks about this. And can I ask the other attorneys to give an opinion? Well, we heard from the Supreme Court, but in practice, many practitioners think that it is still, valid. And when it comes to the passive confirmation trial, I mean, there were some cases where I saw the parties settling thanks to that, so there could be some validity to it. But then, from a more detailed point of view, there could be some problematic aspect to this system. Despite that, I mean, this is a confirmation, and this is also related to administrative aspect as well, not just judicial one. So maybe having a confirmation only that may stay, that may be able to be maintained without any problems. I will think about this even more deeply afterwards. So, Mr. Lee, could you share your thoughts on whether this would be if this is an effective system, and what's your view on this? Well, this is a system only existing in Korea, and should it really go into a trial, maybe eliminating it completely or reducing its scope is something that I hope to see in the future. But when it comes to the passive confirmation trials, and even the ones that will be held in the future, I mean, this is still allowed, and I have a lot of questions about this because I mean, this actually system is in place because of the legal certainty. But then, if we have a right to claim for the confirmation trial, even for the items that will be, put in place afterwards in the future, then it is actually going beyond what it is designed for. So I will be implementing this claim in the future. That is the argument that the patentee makes when they're making that claim. But if that is allowed, who would be completely ready when they are making the argument, right? So from the respondent's point of view, I mean, they would be going into this dispute regardless of whether they want to do it or not, and regardless of whether they did something wrong or not, and be wasting a lot of time and money. So when it comes to the confirmation trial, I mean, that would be specifying the target opponent. But then when you are actually implementing it in another, invention, so in the confirmation trial, you use item A, but then in the actual implementation, you use an item B, then there is a contradiction between the two, and that will give rise to another litigation in the future, which is related to the actual rights. So this may be resulting in unnecessary disputes even. Thank you so much for your view. Moving on to the last topic.
So to Mr. Han's presentation, the International Judicial Panel need to look at more cases. So specific way would be allow other language besides English, and in proceedings without getting consent from the opposing party, you could still pursue with the International Judiciary Panel's proceedings. So the applicant please in foreign language, and if they submit briefs in foreign language, that the applicants, might find it easy, but the opposing party, like Korean party, although they did not agree on this, they have to do everything in English, although they're doing this in Korea. So if it's an international case, yes, it could have bring more foreign clients to Korean court, but Korean company that has to go through these proceedings as an opponent, what kind of benefit can they enjoy? Now, in terms of translation, if you look at Article 4 related to the operation of the International Judicial Panel, they say they can establish interpretation service center. So we have done few cases already, and the simultaneous interpretation service was availed through the court. I believe a translation service, written translation service can also be availed through the court. So I only do not plead, plaintiff case, but also defendant case. But there is no proceeding that satisfied all parties. If it's quickly done, maybe it's really satisfactory only one party. So when I was in the U.S. court, what was impressive was that judges say, quote unquote, my court. So in my court, they say I'm the king. So this is Korean court, and they have to abide by the Korean rules. And if you state then it will go. So if everything there cannot be where you satisfy every body. So if there is a bigger kind of value involved, maybe sacrificing few minor interests would be acceptable. Well, I do have more questions. I'm even open the floor to the question, but due to time constraint and as a moderator, I'm obliged to serve my role as timekeeper. So I'll end this session here, and please thank our panelists' efforts with one round of applause.
감사합니다.
Thank you
바쁘신
so
가운데도
much,
유익한
and
세션을 준비해 주신
thank you,
한국지적재산권변호사협회 연사분들께
the
깊은 감사드립니다.
panelists
다시
and the
한번 큰 박수
moderator
부탁드리겠습니다.
for this session for their input and efforts.
잠시 휴식 시간을
We'll
가진
now
후에
get a
오후
short
3시
break
30분부터
and
오늘의
resume
마지막 세션을
with the
진행하겠습니다.
last
많은
session of the
관심과
day
참여
from
부탁드립니다.
3:30.